New podcast, super excited. Marlene Goldenberg, one of our great friends of the firm. For the people who don't know, my background is a special victims unit prosecutor, and Marlene and I have shared many a long phone call about what sexual assault looks like from a civil law perspective. And she's just coming off this really revolutionary trial verdict in the Uber sexual assault litigation. She's one of the brains behind bringing accountability, not just to perpetrators of sexual assault, but companies who, in our opinion, allow for sexual assaults to occur in the United States. So we could spend all day talking about Marlene's background, history, her fabulous law firm. So Marlene, tell us a little about yourself and let's get into it.
Thanks for having me on today. So I am one of the founding partners of Nye Goldenberg, Raso and Vaughn, and I am originally a Minnesotan, always will be, but live in DC right now. Devote a large portion of my practice to representing survivors of sexual abuse and sexual assault. Today, we're going to talk a little bit about the Uber trial, but I have worked in mass torts since I was 14 years old when I worked at my parents' law firm, and I've done every job in it, and I'm really, happy and lucky to now be owning a firm and representing people that I really care about.
We'll dive into your firm at some point today a little bit too. Wonderful partners, a great partnership between our firms. Tell us about the Uber trial.
This trial started from a multi-district litigation that's consolidated in the Northern District of California. And the entire multi-district litigation is a consolidated group of largely women, but some men as well, who were sexually assaulted in Ubers by their drivers. It's a really important and timely case, and certainly a very important issue of the day. But the first trial that moved forward involved a plaintiff named Jaylyn Dean, who courageously stood up and told her story and was the first person to get out in front of this litigation and help everyone by being willing to go through this process. But she was in flight attendant school, had been staying at a hotel in Arizona while she was in school, and came back late at night, and unfortunately, was paired with a driver that Uber had some indications was already not the safest person out there, and unfortunately was raped on the way back to the hotel where she was staying that night. It was a long fought battle. The trial was over 3 weeks long, and we're very pleased that at the end of the trial, the jury returned a verdict in favor of Miss Dean to the tune of $8.5 million.
These are huge companies that we sue. And Uber is a very, very large entity, very well funded, very aggressively defends. And how does a group of lawyers bring a case against Uber or any other entity? And then what role did you have in that?
My role in the case is that I'm one of the co-leads of discovery, and discovery is a very long process of gathering evidence and documents and taking depositions and everything and getting the case to trial, right? And so in order for this trial to move forward, there were tons and tons of lawyers. I was one of them, and I'm very proud to be part of this great team who brought this case. And I can tell you that all of us who were working both in person and remotely, we're spending, getting maybe 3 hours of sleep at night for the entirety of the trial in order to move this whole process along. It takes a lot of people to go up against a big company like Uber. But I think we're able to show the jury and tell the story, both of Miss Dean, but also the liability story of what happened at Uber that led us to this moment.
So the great question I think that everyone wants to know is, there's no doubt that the driver of that car did something horrendous. Why does some company have legal responsibility for the actions of a bad actor?
It's a great question. And actually, one of Uber's biggest defenses throughout this entire litigation has been that rape is a societal problem, as if to imply that because it happens in society, it's not Uber's fault, right? And I take great issue with that because Uber created this platform, right? And if you look at the statistics about sexual assault, the vast, vast majority of sexual assaults that occur in the United States, at least, and I'm sure global statistics would mirror this as well, occur between two people who know each other. And so the likelihood of sexual assault by a stranger in society is actually quite rare. What Uber did by creating what is, I think, unquestionably a revolutionary product and industry, is on one hand very cool because it gets you from point A to point B, but on the other hand, they also created a very dangerous product that needs to be controlled, right? You're now pairing two strangers in a car in an enclosed space that's moving that you can't get out of, right? So it creates a big vulnerability. And to say that this is just a societal problem while ignoring the fact that this is a product that Uber created, they need to be taking some ownership for the fact that they're the ones who caused this pairing to exist.
Car accidents are a societal problem. We still sue people who crash into each other.
Well, my thought too would be crimes are sometimes can be based off opportunity. So you are creating an opportunity that someone is vulnerable.
That's exactly it. Rape and sexual assault is a crime of opportunity, or it can be, right? And so Uber is creating that opportunity for drivers. And you can't create an opportunity like that without controlling for the risks. And that was a big part of the case that we brought, was to say Uber needed to do and continues to need to do a better job of controlling those risks if they want this product out there.
We couldn't watch the trial on TV. There's no recording of it, I don't think, on the internet. But so for the people who don't know, what was the kind of opening statement of the plaintiff, and what was at the end? What did your team stand up and ask for, and why?
So the opening statement and the closing statement kind of has two parts, right? There's the part about Miss Dean, and then there's the part about what Uber did. And I'm going to focus on the part about what Uber did, even though the star of the show truly was Miss Dean, and what she was awarded an amount of money because the jury decided that she deserved it. Right. But in opening and closing, what was made clear to the jury was that they were going to hear a story about a company that put safety at the back of the line. They prioritized growth. They were very concentrated on disrupting the industry, on making as much money as possible, on raising capital, on expanding the number of drivers and passengers. But while they did that, they forgot about the people. They forgot about one of the biggest aspects of taking a car alone at night after you go to a bar and you've lost some of your inhibitions, which is you need to get home safely. And they talk about that in their advertising. Uber advertises all over the place that they are a safe ride home, that they are a safe alternative to drunk driving, and that they're going to get you home with the peace of mind that you're going to be okay. The problem is they didn't build their product that way. They know they have a sexual assault problem, but they didn't control for it nearly as well as they should have or were capable of doing.
Product liability, design defect theory of liability, and a failure to warn theory of liability, are those some of the actual legal issues that we're talking about here?
There have been cases brought on products theories. This trial proceeded on a negligence and an apparent agency theory, and the theory that the jury actually awarded damages on was an apparent agency theory. So apparent agency can exist when the person who's injured believes that the person who hurt them was acting as an agent of the company, even if they weren't actually an agent. And that's important for Uber, who maintains vigorously that their drivers are not employees, but independent contractors. But at least under Arizona law and the laws of several other states, but I won't bore you with a 50-state survey on apparent agency law. If someone like Miss Dean believed that her driver was acting on behalf of Uber, then Uber is still accountable for the actions of its drivers.
I mean, we're taught not to get in cars with strangers, but these apps are saying it's okay to get in cars with strangers. So you have to provide safety with that, I would think.
That's exactly it. I mean, Uber monetized hitchhiking, right? I mean, for years it was, okay, you can hitchhike. And then everyone figured out, oh, maybe that's not so safe. And hitchhiking stopped.
Yeah.
And then we got, professional drivers who were background checked. And I mean, think about how hard it is to get a taxi medallion in New York, right? You had to know every single street. You had to go through crazy background checks. And then when you got your car, it comes with a divider. A lot of cars have cameras in them. And now Uber is like a step back in regulation and safety, right? Now it's all of a sudden oh, it's okay to get in a car with a stranger as long as the app tells you to get in the car with them, because they're telling you which stranger to get in the car with, as if that's different. Well, we've all been trained to believe that it is, right? Which is kind of crazy.
Right. As a customer, I would just assume that the company has done some vetting process that the person you're putting me with would be safe.
Yeah, no, I mean, in fairness, and I want to be intellectually honest about this, Uber does some level of diligence on their drivers, right? Like they do a background check and they're very vocal about telling everyone about their background checking process. And they do have some other checks in place. And there are certain things where if you get, a certain number of complaints, they might kick you off. We can't go into the details of those because they're subject to a protective order, but Uber does have some controls. But where we take great issue is that they have enough data where they could have way more controls. And that's what the jury heard at the trial, was they heard about all of these supposed safety features compared to how ineffective they actually are in preventing things. So you kind of have I was calling it SINO, it's safety in name only, right? But if they were serious about their safety program, they have so much data that they could have leveraged it to do a whole lot more.
One of the topics I wanted to talk about is what came out at the trial regarding the use of safety algorithms at Uber. And I think everyone is really interested about the safety of Uber, but also how the algorithms and any technology that we're all exposed to every day affect people's daily lives. And I think I know you are uniquely qualified to talk about some of the algorithms that Uber were using and just kind of offer your own opinion about what that means for us as a society, I guess.
Yeah, I can't talk in detail about the algorithm because we do have a protective order, and I want to make sure that I'm on the right side of that line. So what I can tell you about is, what you could find in newspaper articles and what came out at the trial. So we're going to stick to that today. But yes, Uber has an AI machine learning algorithm that ranks every potential pairing on a 0 to 1 scale for a likelihood of sexual assault occurring during that ride. So Uber knows that sexual assault is a big enough problem that this is something that they screen for and rank every single time they pair a driver and a passenger in a car. It is incredibly important because this show, being able to build a model like this, are you going to have 100% precision on predicting sexual assaults? No, but we can get a whole lot closer today than, we could have 10, 15, 20 years ago, right? And so knowing that Uber has these capabilities, with great power comes great responsibility. And they have a whole lot of power and a whole lot of data. And what we told the jury and what the jury apparently, sided with us on was that Uber should have done more with the information that they have.
What does that mean for other cases or other litigations or other technology companies, just as a lawyer, not specifically related to any facts or circumstances, but what does it make you think about?
Yeah, well, I mean, we're in this new frontier of, I would say, moving into the product liability law now, right? When you build a product, just let's talk basic product liability law 101. When you build a product, you have an obligation to anticipate the risks associated with your product. And the first thing you're supposed to do is you're supposed to grade those risks based on severity and frequency.
Can we talk about the Easy Bake Oven? Your firm's experience with the Easy Bake Oven, because this is a very clear example.
Okay, this was my dad's case when I was a kid, to be clear. This was not mine. This was a case that I remember paying attention to as a child. But my dad's also a lawyer and I used to work for him. So Dad, here's your shout out. He had a case involving an Easy Bake Oven. And in the Easy Bake Oven, the company had redesigned the product, this was years ago, to have something called the magic spatula. And those of us who had Easy Bake Ovens as little kids, you remember there was a light bulb inside that was your heating element that would cook your tiny little cake that was about this big, right? And when they redesigned the oven, they put 2 doors on either side of it that worked like the doors on a VCR. So now we're all going to really date ourselves and, talk about the correct era. But when you put something into a VCR, it's a one-way swinging door, right? It doesn't go both ways. So you would take your little magic spatula and you would push your cake through the door into the oven, and the door would close. And then when the cake was done, you'd push it out through the other door and then it would come out, right? And then this one little spatula tool would push it all the way through. The problem is you're designing this product for little kids. And what do little kids do? Well, they stick their fingers in things. So when a little kid sticks their finger in a door that swings only one way and they try to get them out, well, now they're stuck, right? And they're stuck in a very hot oven and they're getting burnt. It's a perfect example of a risk that should have been anticipated by the company. And if my memory serves me right, they redesigned it after that case. So thanks, Dad, for ruining my favorite toy. But no, in actuality, it was a really good change. And there were lots of kids whose fingers got burned, or like fire departments had to get called because of that thing. So now let's fast forward and think about technology companies, right? Uber builds this platform, this marketplace where they pair people. People are the commodity on this product that they're making money off of, right? So when you pair two strangers together, I mean, let's think about the crazy things that can happen, right? There's physical violence, there's sexual violence, and there's theft. Those are your three big things that you're probably going to worry about when you're putting strangers together in an enclosed area. So again, if you're designing a marketplace like that, you have to control for those risks. And now, yes, I think it's going to be more of a mandatory standard of practice for companies to need to use all of the data that they have, because they do when they make money. So they should when they're protecting people and doing risk management, right? The data should be used just as powerfully in generating income as it should for controlling risks. And there are a lot of companies that are starting to rank risks and use AI models to quantify and then control for risks. And you see it happening in airplanes, even with delivery companies and other companies like that too.
Right now, we have a social media addiction trial, bellwether trial going on. There's a jury out really as we're recording this right now. And it seems as lawyers, the iPhone came out 20 years ago, and there's been development of apps for 20 years, but it takes the law a while to catch up. You probably, the first Uber sexual assault lawsuit was filed, many years ago, and we're getting a verdict today. It seems to me that this is an area of law that will continue to develop over the course of the next 10 years. There will be more real product liability litigations focused on app designs, software designs, things like that.
I think that's absolutely the case. Yes. Now, the good news is, even though our justice system moves very slow, we're still faster than the regulators. So I was actually just before this talking to somebody about how the legal system and the civil justice lawyers are actually one of the last checks on the system. And that even though regulators are often slow to control for things, we're kind of the last line of defense until the law catches up. So yes, it's going to be a very important part of our job, I think.
I think it's accurate also to say that regulators will oftentimes learn a lot from trials as well. Everybody can put their best foot forward when talking to regulators, but when you get in a courtroom and you swear under penalty of perjury and testify, it's a little bit different than submitting forms to regulative bodies, it seems like. And there's cross-examination and there's follow-up. And sometimes trials have regulatory effects as well, which I'm anticipating will happen.
Well, and we did see some changes as a result of our litigation, right? I mean, Uber didn't directly say that it came out as a result of our case, but I will say that coincidentally, during the time in which our litigation was pending, Uber released its women-to-women driver and rider option. So now when you log into Uber as a woman, you have the option to tell Uber, I would prefer to be paired with a female driver. And I mean, that is a statistically proven way to reduce sexual assault, is to pair women with women.
So you have another case you want to give us a sneak peek of?
Well, maybe. I mean, as we're talking about technology, and there's great things about it, and there are things that need to be controlled, right? So I'm not an anti-tech person. I really love looking into the new things that are coming out. I'm excited about them. But again, when you prioritize growth over safety, that's where we come in, right? We got to poke people a little bit to make sure they stay in line. And so one of the things that I'm paying close attention to right now is the deepfake porn industry. Because with all of these cool AI models that can generate pictures of you, looking great in a bikini, somebody else could just as easily turn that picture around, crop your face, and put you on a naked body and tell everybody that it's you. So again, funny uses of technology, cool. There is a dark side to this that we need to be controlling for. And I think trial lawyers are going to play an important role in making sure that adequate protections get built into this cool new technology that's coming out.
Yeah, because are there any laws on for or regulations on things like that?
It's funny. There's actually one that's pending right now in Congress called the Defiance Act. It's passed through the Senate and it's been sitting in the House, and it got introduced last year, didn't pass, but it would introduce civil liability for deepfake porn creation. And we will have to see what Congress decides to do about it.
What's the argument against it? Why would somebody in Congress say that that is okay?
I could give you a list of Congress people to call and ask that question to.
Yeah.
But there really aren't any laws to protect anyone from any of this stuff at this point.
That's where a lot of times where there aren't explicit laws, that's where you fall back on good old fashioned tort law. So I have a different case right now where I represent some hostage families from October 7th in a case against Binance. And we have sued Binance under the anti-terrorism statute, which exists under federal law to protect victims of terror. But we also sued them under good old-fashioned negligence and product liability principles for many of the same reasons that we've talked about. And that is kind of the nice thing about state tort law is it does provide some blanket protections for victims that can be used when anybody acts below the standard of care. I mean, that's what a negligence claim is for, right? And a product liability claim exists for when product manufacturers aren't careful. I mean, that's the point of it, is that we should have safe products on the market.
Is there like a statute of limitations or a timeline that this has to be within?
Yes. The short answer is yes. The longer and annoying lawyer answer is it depends on each individual case, and we always look at it closely. In broad brushstrokes, keeping in mind that this isn't an analysis of anyone's individual claim, we would calculate it based on the date of the sexual assault, and every state has a certain number of years that they give you to bring a case. In many states, it's 2 years. That's kind of the average. In some states, it's more. In other states, it can be less. But if something happened and you're thinking about bringing a case, my advice to everyone is always just call the lawyer and find out. Don't wait, because otherwise your time might run out.
And there's a more practical component to that answer as well. As part of our jobs as lawyers is to gather evidence to help you bring a successful claim, and evidence disappears over time. We can find witnesses today. Maybe we can't find a witness a year from now.
Exactly.
It does help us do a better job the closer in time we can become involved to a particular incident.
Yeah, that's very true.
How do you join this claim if you are a victim of this?
Yeah, so I think one of the important things about this is there's a number of ways to participate at a level where you are comfortable, right? So God forbid if this happened to you, it's scary, right? And it can be embarrassing, even though it wasn't your fault. It's a thing that people don't often want to talk about and publicize, and there are multiple ways to go about obtaining justice on your terms. So this consolidated case that exists, everyone still has their own case. I think that's important for people to know. But if you were sexually assaulted in an Uber, it would be helpful if you had your ride receipt so that we could look at what the ride was. We always talk with survivors in a way that, makes them comfortable. We can do a Zoom or a phone call. Everybody in our office has been through trauma training, so we understand, how to have this conversation in a safe way. And we try not to make people tell their stories too many times because we know that can be re-traumatizing. And we have resources for mental health assistance if anybody needs that. So the first thing is I always tell my clients, take care of your health first. It's the most important thing you can do. When you're ready to move forward and seek justice, we're happy to talk to somebody. And we can do this in a number of different ways. There are ways to bring individual cases, and then there are also ways to join this case out in California, which for a lot of people has the benefit of adding a little bit more anonymity to the process, where you don't have to be out front. You don't have to have your name on things. And we can file cases under what's called a Jane or a John Doe filing so that your name actually doesn't go out in the public sphere. Some people do want to file under their name because they want to show the world that they're standing up, and we can do that too. So we try to offer a number of approaches that don't just allow people to get money, but also to use this as more of a healing process, which I always
Right.
hope for my clients that it can be.